All right, looks like people are coming in. Hello, everybody, and welcome. We're just going to let people come into the room for another minute or so. If you can use the chat to let me know that you can hear me clearly, that would be helpful. Okay, excellent. Thank you. Okay, well, I think we can begin. Hello, everyone. Bienvenue. I'm very pleased to welcome you to this webinar. My name is Kristin Marshall, and I'm a lawyer trainer at Community Legal Education Ontario. With me are our presenters, Martine, Cétoute, the staff lawyer at Community Legal Services in Ottawa, and Gillian, Reiss, the staff lawyer at Willowdale Community Legal Services. Very excited to have them both here today. I see you've already used the chat. That is where we will get you to respond to questions as we go throughout. And of course, that's where you can post questions to our panelists. This training represents a collaboration of a few legal clinics, practitioners in social assistance and immigration law. Training is often on either area of law, but the importance of how these two topics interact is, of course, significant and relevant to OCASI members and friends. This training is part of a series of topics, legal topics, that CLEO is developing with our clinic partners, funded by the Law Foundation of Ontario, that will help legal clinics provide information to community workers in their areas. We include scenarios for discussion, and we'll try to answer all of your questions, and the slides will be available on the conference website. There are resources listed at the end of the slides that we think would be relevant to your work. Will be two, we actually won't have a break, but we will have two question periods, kind of after the first section and then again at the end. So you'll have a chance to pose questions then. In terms of our learning goals for today, of course, it's not to make you experts in either area of law, social assistance or immigration law, but to increase your understanding about the eligibility of your clients for social assistance, as well as the consequences that receiving social assistance might have to some immigration applications. The backdrop to this presentation is that we need to keep in mind, of course, the many barriers that exist for refugees, live-in caregivers, migrant workers, and undocumented people in Ontario. Fears about precarious status, language barriers, and the lack of information and resources compound this disadvantage. People are living in deep poverty. The social assistance as it is woefully inadequate, with roughly $730 for somebody to receive Ontario Works per month, and that includes basic needs and shelter, and somebody who's living on Ontario Disability Support Program receives just over $1,100 per month. Those of you who work in this sector are well aware of the exploitive dynamics at work and other relationships that can result in the need for social assistance, financial assistance. Sometimes barriers come within social assistance institutions themselves. This presentation aims to address the misunderstandings, the negativity, and the reluctance sometimes to accept applications for assistance, or the reluctance to push to apply and request a decision. So without further ado, I turn it over to Martine Cétoute, and we look forward to hearing from both you and Gillian. Thank you.
Thank you, Kristin. So I will start us off by going over some of the immigration statuses in Canada. And my colleague Gillian will then explain to you how those statuses can affect eligibility for social assistance. So we're going to move on to the next slide, and we're going to start off with who is a citizen. So there are a few ways that a person can become a Canadian citizen. The most common way is for people who are born in Canada. There's also naturalized citizens who become citizens after their arrival in Canada. So these are people that are born outside of Canada and have gone through the immigration process. And then there are also minors who can become citizens either through a parent or legal guardian, and there may be other categories as well, but we've just listed a few here.
So how does social assistance treat citizens? Well, citizens are eligible for social assistance. That's the easiest one, I guess. Of course, even when someone is eligible for social assistance based on their immigration status, they still do need to meet all of the other eligibility criteria. We're not going to go through them in detail today. This presentation isn't about social assistance eligibility in general, but those things include their income, assets that they have, if they own a boat or a large bank account, where they're living, who they live with, that sort of thing.
And then the next status is going to be permanent residence, which is someone who's given permanent status in Canada, but is still a citizen of another country. So there are many ways that a person can obtain permanent resident status in Canada, and that's usually through an application that's sent to Immigration, Refugees, and Citizenship Canada. And there are many types of applications. And we're going to discuss maybe a few of them today, but just like Gillian mentioned, it's not meant to be a presentation about immigration law, but just to give you the basics so that you have a better understanding of the status and how there can be an impact with social assistance. But I just wanted to mention that permanent residence, although we do see the word permanent, is not always what it claims to be. It is possible to lose permanent resident status as a result of different things. For example, a criminal conviction, or if someone is outside of Canada for too long, or in some cases, if someone may have lied on a previous application or something of that nature. So it's just to at least be aware of that. And also just to mention as well, some people may know the term permanent resident as landed resident, which is a term that was used before.
So like citizens, permanent residents are eligible for social assistance, as long as, of course, they meet the other eligibility criteria. So when they're asked for documentation about their immigration status, they can provide the basics like a PR card or a record of landing, that sort of thing.
And then I mentioned earlier that permanent residents are people who applied to IRCC, and we've just included a few examples of the types of applications that people can make in this context. So spousal sponsorship applications, for example, a successful refugee claimant can apply for permanent residence. And then one of the common ones that we see in our office are humanitarian and compassionate grounds applications, which we will talk a little bit more in the next slide.
Sorry, I'm just getting a message that at least one of the participants can't hear. Is it at all Fuzia, or is it Martine or me or Gillian? And is it any better now?
I can hear everyone, just so you know, so it might be a local problem.
Okay, okay. Okay, great. Okay, maybe log in and out again. Okay, all right, thanks everybody. Sorry for the interruption.
That's fine. Okay, so just briefly, what is an H&C application, which is a humanitarian and compassionate grounds application? So it's a permanent resident application that's made to IRCC from inside Canada. In most cases, it's usually made by a person who has no status in Canada. They are highly discretionary, and these are applications that can take quite a long time to be processed by IRCC. A few considerations for people who do file these types of applications are some of the factors that IRCC will look at is, for example, their establishment in Canada, the length of time they've been here, family ties, etc., and also the hardship that they would face if they had to leave Canada and apply for permanent residence from outside of Canada. And another important factor that IRCC will also take into consideration is, so if that individual, for example, has a child or children, or there may be a child or that could be impacted by this decision, then that's a factor that they'll take into consideration as well. So they will look at the best interest of a child. One thing that's important to note is when a person is applying for H&C, while their application is in process, there is no stay of removal. And that's a concept that I'll discuss again a bit later, but essentially that means that there is still a risk that they may be removed from Canada during the processing of their application. So this means also that if someone is applying for an H&C, they're going to be giving their information to Immigration Canada. They're going to be giving their name, their address, and their contact information. So that does increase their visibility with Canada Border Services Agency. And then also, if, for example, that person is in receipt of social assistance, then that can be seen as a negative factor for their application and can decrease, that level of establishment that many applicants are trying to show that they have. So it's just something that we wanted to mention for these types of applications.
So as what Martine just said implied, PR applicants are eligible for social assistance. This is a bit of an odd one since it's not really a permanent status. You can be removed from the country while you're doing an H&C applicant, but in the meantime, while you are here, you are eligible for social assistance. To prove you're eligible, you may be asked, to provide a copy of a letter that you've submitted, an acknowledgement receipt from immigration, even proof that you've paid. Some social assistance offices are more likely than others to accept a letter from a lawyer saying that you have done an application. So it's important that people have their documents available just in case they need to show the social assistance office that, in fact, they have done a permanent residence application. With that said, just a reminder, like Martine said earlier, that receiving social assistance could affect the application, though. So it's something to keep in mind and to talk to immigration lawyers about if the person has an immigration lawyer.
So we're going to move on to the next status, which is refugee claimants in Canada. So a refugee claimant is someone who has fled their country and is asking Canada for protection. We use the word claimant to show that it's someone who's made an application. They're waiting either for a hearing or a decision on their claim. They may have already gotten a decision and they're appealing that decision. And they may even be applying to the Federal Court of Canada to review a negative decision. So during all of that time, that person is still considered a refugee claimant until they've exhausted all of their appeals, etc. And then at that point, if they've exhausted everything, then they would have no status. And if they're successful, then they would move on to a different status.
So social assistance does treat refugee claimants as people who are eligible. So that means, again, someone all along that process, even if they've been rejected, they're doing appeals, they are eligible for social assistance. It used to be, and some of you may remember, a time when refugee claimants could only receive emergency assistance from Ontario Works. They weren't eligible for regular assistance from Ontario Works or ODSP, but that's changed. And now refugee claimants are eligible for regular assistance. That said, there are some kind of holdovers from previous times. So sometimes caseworkers will ask clients for regular updates. The key being that they don't want to miss if the person either was found as a protected person or was rejected. They don't want to miss the change in status. So sometimes they'll say every 6 months, every year, that they want an update on what's going on with the refugee claim.
So we talked earlier about refugee claimants, and I mentioned that if a refugee claimant's application is accepted or claim is accepted, then at that point they become a protected person. So a protected person or a convention refugee is usually the term that's used. It can also be used in a case of someone who applies for what is called a pre-removal risk assessment. And I think we're going to talk about that briefly in further slides. And Gillian's going to talk about whether or not protected persons are also eligible for social assistance.
So this one's, again, one of the easier ones. So protected persons are eligible for social assistance. They need to show that they're protected persons, of course, but that eligibility is automatic as long as they qualify otherwise. In terms of applicants, as Martine mentioned earlier, these are people who are also making a claim that they need protection from Canada. And so social assistance treats them in a similar fashion to they do refugee claimants. And they find that applicants, so people who are applying for protection under a pre-removal risk assessment, are eligible. We're not going to go into the specifics today about how PRAs work and how you do them, but just know that if someone is a applicant, then they would be eligible for social assistance until there's a decision on that.
So I'm just going to briefly talk about removal orders. The reason why we're bringing this topic up is just because in the context of social assistance, the social assistance is often focused on whether the person that's applying for the benefits can be removed from Canada. So the question that they often ask is the removal order, if there is one, is it enforceable? So there are 3 different types of removal order. And we've listed all 3 of them here. It's not really important to know the names because it can be a little bit confusing. But the point is just to know that this is basically, there's 3 different types of removal orders, and social assistance matters really look at the question of removal when it comes to applying for benefits. And so if a person is removal ready, that means that they can be at times removed to their country of origin, but not every removal order can be enforced. And again, this is a bit of a complicated topic, so we're just going to go over or kind of gloss over it a little bit. But there are certain processes where people cannot be removed from Canada. We've already listed some of them. For example, if you are making a refugee claim in Canada, then you can't be removed to your country of origin while you are waiting a decision on that claim. And even while you're appealing, or if you're filing an application with the court, you're even if you have a removal order, that removal order is not enforceable. There's also situations where certain people come from countries that are unsafe, and Canada has made the decision that they will not remove nationals to certain foreign nationals to certain countries, and those are known as countries where there's a temporary suspension of removal or an administrative deferral of removal. And there are many countries that are listed on the list, this list, which we've provided, I think, a link at the end of the presentation where you can find that list of countries. And other examples that we've provided of removal orders that can't be enforced is in cases where The CBSA will agree not to send an individual back to their country for whatever reason. It could be because, you know, they're still appealing a decision or whatnot. And also a federal court judge can make a decision and determine that someone will not be removed to their country as well. So these are just examples of cases where removal orders aren't enforced. And I think really the important thing to note is that in most cases, and most people who are applying for social assistance, even though there may be a removal order, in most cases it isn't enforceable. So that's something that's really important to remember in this case.
And why is that important? Well, this is the first one where we're going to answer that no, certain groups of people are not eligible for social assistance. So people with removable or enforceable removal orders, are not eligible for social assistance. But there are exceptions to that. And those are the exceptions that we really care about here that we want to focus on. So the first one is the thing that Martine has been talking about. Is the removal order enforceable? If it is not enforceable, that means the person is not being removed from the country. They're staying here. They need support. They need to survive. They're eligible for social assistance. But there are other exceptions as well. If the person's made a humanitarian and compassionate application, then they are eligible for social assistance as well. And this is kind of a big category. If the person cannot leave the country for reasons beyond their control, they are eligible for social assistance. So if they have an enforcement order, even if removal order, even if it's enforceable, if they can't leave the country for reasons beyond their control, then they should be eligible for social assistance. This can include people who CBSA is having a hard time getting travel documents for them to return to their home country. But we've also seen cases where there is an order, but CBSA isn't acting on it, and the person couldn't afford a plane ticket to leave the country, for example. There's no way for them to get to their home country to leave Canada. So we've argued that people are eligible in those situations as well. This is one of the tricky situations, though, when someone's applying for social assistance, in which case they may need your help, because social assistance offices often hear, oh, well, there's a removal order, so you're not eligible, and that's the end of it. And often people don't realize that they can prove that the order isn't enforceable. So I've had a client, for example, he was from a country to which removals were not taking place. He was from Syria. And there was a removal order against him. So he was told, no, he wasn't eligible for social assistance. And when we looked into it further, we were able to prove, here's the list. This says that Canada isn't going to send him back to Syria right now. So you do need to give him social assistance.
Okay, so now we'll just move on briefly to a few temporary statuses in Canada, which one of them includes temporary resident permit holders. Just to briefly mention, so a TRP it used to be called a minister's permit. It's a discretionary tool to get around or overcome an inadmissibility to Canada. So for example, there may be like a medical or criminal factor that may make a person inadmissible because of previous immigration enforcement actions. So a TRP is a document that's issued by IRCC, and it allows people who are technically inadmissible to Canada to still visit the country or stay here temporarily. As we mentioned, it can be valid it could go from a day to 3 years and can be canceled at any time. A TRP should not be confused with a TRV, so a temporary resident visa, which is a document that's usually issued for someone who wants to travel to Canada, a visitor, a student, someone who wants to come to Canada to work. So that's usually a document that we would find in a passport, whereas a TRP holder is really a category in immigration law for someone who's considered to have a temporary status. So they have an actual document, and then sometimes these people can even get permanent residence if they've been a temporary resident permit holder for a certain amount of time. I did also want to mention, since we're talking about temporary statuses in Canada, that if someone has status and but their status is going to expire, they can apply to extend that status before it expires. And when they do that, they will have what's called maintained status, which was previously called implied status. And people who have implied status would still fall under the status of either a TRP holder or another temporary status. And then also, if even in times where status may expire, there is also a possibility to be able to apply to restore that status within 90 days.
So temporary resident permit holders, including those with maintained or implied status, are eligible for social assistance. Again, it's one of those categories where the local office, when the person applies for social assistance, might not really understand what the status is and may need some help to interpret it. So it's another area where caseworkers or local legal clinics can get involved to help explain that and explain why this person would be eligible for social assistance.
Okay. And then for the final status, so we're briefly going to talk about what is a visitor. Gillian's going to talk a little bit more about that and explain a bit this chart that we've prepared, because as you'll see, there are different definitions. But in immigration law, a visitor is someone who is authorized to enter Canada and stay in Canada on a temporary basis. So it's one of those temporary resident statuses that I mentioned earlier, but it is not a TRP. Other temporary statuses can include workers, international students, but workers and international students are not considered visitors in immigration law. And then I'll let Gillian explain the rest of this chart.
So this is where it gets interesting or confusing, depending on who you are and how you feel about it. Is that with all the previous statuses, it was pretty clear the link between what immigration law says and how social assistance treats someone with that status. Well, with the status of visitor, there is no direct link between those things. So the term visitor is not defined in the law associated with social assistance. And so the ministry, so the government of Ontario, has created its own policy that says, this is what we think a visitor is. This is what we think someone who fits into this category is. And lo and behold, it has nothing to do with anything Martine just said about what a visitor is. So the ministry defines visitor as someone who's in Canada for a temporary purpose. And Martine specified that students and people here on work permits are not visitors in immigration law. Well, the ministry thinks for social assistance purposes, they are visitors. The ministry also includes something that it calls people on a tourist visa, which isn't a thing that exists under immigration law, yet it is in the policy. And it includes people who are here on temporary relocations from other countries. And that could include things like natural disasters, forced community evacuations. So they have this huge umbrella, the ministry, of how they define what a visitor is that doesn't really relate to how immigration defines visitor. Social assistance offices tend to do what the ministry tells them to do. They look at the policy. They don't always look at the law as it's written. So the policy says tourists, visitors, students, people on work permits, people who are temporarily relocated, they're not eligible for social assistance, or they are considered to be visitors. So local offices are going to tell people you're considered a visitor if you fall into one of those categories. Now, the Social Benefits Tribunal sees it differently. The Social Benefits Tribunal, in a recent decision, had said that we really have to look at the plain language. What does visitor mean? The regular meaning of the term visitor, what is that? So who is a visitor? The dictionary says a visitor is a person who visits a person or a place, or a person who goes to a place to look at it, or go and see and spend time. So the tribunal has said that this is what a visitor is. So it's not what immigration law says it is, as Martine explained. It's not what the ministry says it is, according to the policy that I explained it in its big breath. This is what a visitor is. Now, the law also talks about tourists. As I said, there's no definition of tourist in immigration law either. So we can only assume that if the tribunal says we should look at what a visitor is in the dictionary definition, then perhaps we should look at what a tourist is in the dictionary definition as well. And so we've put one of the definitions of tourist here. I have to say, often decisions, if someone applies for social assistance, they'll be told you're a visitor or a tourist. And social assistance offices themselves don't seem to distinguish between these two things. But they are slightly different. A tourist is someone who's takes a tour for pleasure or culture. So as I implied, social assistance says that visitors and tourists are not eligible. That means people who fit the definition, and it's arguable which definition, are not eligible for social assistance unless they've made a refugee claim, they've made a permanent resident application, or they cannot be removed from Canada. And we talked about the ability to be removed earlier. So what that means is that people who meet the definition of visitor, who are a visitor, are not eligible for social assistance unless they fall into one of these exemption categories. And I guess the big question is, who is a visitor, who is not a visitor?
All right, so we're just going to segue into a scenario now that we've discussed the different immigration statuses in Canada and whether or not these people are eligible for social assistance. I'm just going to read this out to everyone. So Ilana arrived in Canada as a visitor 2 years ago. She left her country of origin because she was afraid of an ex-boyfriend and the police. She realized that it wasn't safe to return home. She had a son in Canada. She received healthcare for her and her baby, and she developed friendships. She tried to apply for refugee status, but the process was confusing. She's recently retained a lawyer, but has not filed a refugee claim yet. Is Ilana eligible for Ontario work benefits? And this is where I guess we'll give participants an opportunity to just review the scenario and give us your thoughts, like by just answering yes or no in the chat box, whether or not you think Ilana is eligible for social assistance. So I'm seeing a lot of no's.
Yeah, we have quite a few no's there. Does anyone think she's eligible?
You've got, hey,
we
now
got
you're getting some
there.
yeses.
Okay, well, how did they get healthcare on a visitor visa is a good question we can go into later. So yes, Ilana is eligible for Ontario Works because she is not a visitor if you look at the dictionary definition. So since she's not a visitor, she is eligible as long as she meets the other eligibility criteria like income, assets, where she's living, that sort of thing. These facts actually relate to the case that I was referring to earlier, where the tribunal said you had to look at the term visitor in its dictionary definition, or what we call ordinary meaning. So the tribunal found, and I'll just quote one of the main sentences from there, the appellant's circumstances, including the duration of her stay, her integration into the community, along with other hallmarks of permanency, are inconsistent with and not indicative of someone who is a visitor. That term's common and regular usage denotes a less formalized and more temporary connection. So in this case, Ilana, who, as we're calling her today, applied for Ontario Works benefits and was rejected. She was told that she's not eligible. We did an appeal to the Social Benefits Tribunal, and it took a little while to get a decision, but many months later, the tribunal did find that she was eligible for Ontario Works benefits. And some of the things, it is very fact-based, very based on the Elena's situation, because you're looking at, is she a visitor based on this very kind of vague, ordinary meaning of the term? The tribunal looked at things such as she decided to stay in Canada due to fear of returning home. She began a relationship. Even though the relationship ended, she found out she was pregnant. She had a Canadian-born child. She had to move to a larger city to get her healthcare needs met when she was pregnant for that child. And part of that move was based on the availability of healthcare for people without regularized immigration status. She found housing, she had friends, she had a support network. And over the course of her stay, she had looked into applying to make a refugee claim, but it was really confusing. Particularly in her case, she didn't speak English. She had a really rough pregnancy, so she couldn't follow through on things that she was told she needed to do. And actually, one of the lawyers, unfortunately, who she visited at the very beginning, told her that it would be expensive to do a claim and didn't tell her about legal aid services. So she had intended to stay in Canada. In fact, about 6 months after she applied for Ontario Work, she did submit her application and she was found to be a refugee, a protected person. And she was able to stay in Canada. But in the meantime, she needed to survive somehow. Her Canadian-born child needed to survive somehow, and they were eligible for Ontario Works benefits.
Mm-mm.
Just while we are here, Gillian, we are being asked, or you're being asked, did they backtrack the payment for her when they found her eligible?
Yeah, so we're going to touch on that a little bit in a 2 or 3 slides from now, but the short answer is yes.
Okay, thanks.
So just in a summary of all of the slides that we've had about various immigration statuses, it can be really confusing because there's a lot of possible statuses available. But what's clear is that there are certain people who are not eligible for assistance. And the law is formed in the negative, which means if someone doesn't fit into one of the not eligible categories, they ought to be eligible. So the people who are not eligible are people who have enforceable removal orders against them, who have not applied for permanent residence based on agency grounds, and who can leave the country. Visitors who have not made a refugee claim or a permanent resident application, and tourists. And those 3 categories are the only people who are not eligible for social assistance. The ministry policy doesn't say that. That's not actually what the ministry advertises or what they follow, but the ministry policy is not the law. So while it can be confusing, just because the ministry interprets something some way does not mean that that's who is and who is not eligible. It doesn't mean that it's correct. So the tribunal can overrule the ministry, and they have when we talk about defining who a visitor is.
Do you mind if I interject with another question now?
Yeah.
Is if she didn't have a Canadian-born child, do you think she would have been eligible? If you can comment on that, please.
So I'm not the tribunal member, so I don't know how much that weighed as a factor. I think she probably would have still been eligible given the circumstances of her case. So she had still established herself in many ways. She had a relationship, she had friends, she was living here. She had looked into making Canada her home permanently. So I think there probably would have been enough there to show that by the dictionary definition of visitor, she was not a visitor. So just to emphasize that a basic principle of understanding social assistance legislation or social assistance rules is that ambiguity should be resolved in favor of the applicant. So because social assistance is supposed to be a welfare program that's supposed to help people, the way the courts look at it is that any ambiguity, anything that's not clear, we really need to look at it in the most favorable way possible to people who are applying for assistance, people who really need this income source. And there is some ambiguity when it comes to who is a visitor, who is not a visitor, and as well as some other immigration statuses. And the key is that those ambiguities need to result in a favorable decision for the applicants. So we're really looking at people who are not tourists, not visitors, not subject to enforceable removal orders. If one of those things is not true, the person should be eligible for social assistance. Now, that doesn't mean there aren't barriers. Unfortunately, it's not just an immigration status that acts as a barrier to someone achieving or receiving social assistance. As we talked about earlier, people with precarious immigration statuses have numerous additional barriers on top of basic eligibility rules. One big one that we've seen a lot of is that staff at social assistance offices have been known to discourage people from even completing their applications. That means that someone calls in, they say, hey, I want to apply for social assistance. I have no money. I need to pay my rent. And they're told on the other end, oh, you're not eligible. You're a visitor. You're not eligible. And that means that people don't get decision letters. It's not explained to them how to challenge the decision, or that the decision may even be incorrect. Often people with precarious immigration statuses, as you all probably know, they're worried about being found and removed. So if the government tells them you're not eligible for something, they don't think, oh, I should try to challenge that decision. And a social assistance office is a government office for all intents and purposes. So often people will just accept whatever they're told when they call the local office, and that will be the end of it. And we, in fact, find at our legal clinic that clients often come to us after having applied for social assistance, been told they're not eligible, so not completed the application. And then months and months later, they're living off of the goodwill of friends or family, really, really struggling. They come to us for immigration advice, and then we find out they don't have a source of income. And it's at that point we're able to intervene and assist them. So it's really important that people are able to get through that process and through the application process. The other big barrier we find that people encounter is with service providers. So that can include us as legal clinics. Clients can be transient, or they don't fit really well into geographic boundaries because they don't have, either they're moving around a lot, or they have precarious employment and they have to change where they are. They're afraid to reach out for help, or maybe it's difficult to communicate. So at our clinic, we try our best to be flexible to help meet people's needs when they're in these vulnerable situations. So in a perfect world, what does happen? In a perfect world, someone applies for social assistance and they're given a decision. And that decision isn't someone on the phone saying, hey, I don't think you're eligible, but that decision is a completed application. And then the person is given a written decision that includes you're not eligible or you are eligible. If you're not eligible, here's why. And here's how you challenge this decision. And it's really important that people get past that first step. So if they're not told that they were not eligible, then they have the right to continue the application and a right to get a written decision. And that's really important that people have that and are told what their rights are, and they don't just hear a random result over the phone based on an initial conversation. So the question came up about if the appeal was backdated once the person was found eligible for social assistance. Well, this partially answers that question. So if someone gets a decision and the application was denied, so the person's found not to be eligible, and we'll go with Alana as an example. So Alana was eventually, actually, we had to argue to get a decision in her case. She came to the office and they refused to give her a written decision. They just said she's not eligible. And we said, no. In fact, you have to give her a final decision on that. So we got the decision. We did an internal review request. Then we did an appeal to the tribunal. And when we did the appeal, we requested something called interim assistance. And what that is it's the tribunal ordering that the social assistance office has to pay the applicant until the point that the tribunal's made a decision about the case. So this meant that Alana was able to get Ontario Works benefits from the time we appealed until a decision was made in her case. Now, if she was unsuccessful, if the appeal was rejected, technically she would owe that money back. She would have to return that money to social assistance. Often clients tell me that this is a future me problem because in this moment, I really need the help. So they're able to survive based on getting this interim assistance. But because she was successful, she was found to be eligible for social assistance, she was able to keep that money. So a few major takeaways from this is, what can community workers do? Well, support clients in getting applications, including completing applications for social assistance, and just letting people know that they might be eligible, even if they think that they aren't, even if they think because they have precarious status in Canada, they aren't eligible for anything from the government. I would recommend if the person has an immigration lawyer, it's probably worth consulting with them first as well. And the other big thing that community workers can do is really engage with your local legal clinics, particularly when it comes to the legal processes. So if someone gets a decision letter, then a legal clinic can really help out in the formal process, like filing an internal review or an appeal. And we just wanted to highlight one of the things that my colleagues out in Ottawa were doing in order to reach out to people rather than just waiting for people with precarious status to come to their office. They have gone out into their community to let people know that just because of your precarious immigration status, that doesn't mean that you're necessarily not eligible for social assistance.
Great. So this gives us an opportunity to open up the floor for questions. I did notice that somebody had asked Gillian how Ilana got, and of course that's a fictitious name, how she got healthcare for herself and her baby. I don't know if you'd like, and somebody else asked for the code number to the SBT's decision. So if people were wondering why I was leaning away and doing something else, I've shared the code number and also the name of the Wellesley Institute Network for Healthcare for the Uninsured, but maybe I'm scooping you there.
Yeah, so the reason, as I said earlier, the reason Alana moved to a bigger city, Toronto, as it was because where she was, there wasn't healthcare available for people without regularized immigration status, and there are in more major centers. So there was healthcare available to her in Toronto. Her baby is a Canadian citizen, right? Her baby was born in Canada, is Canadian, and so his healthcare was easily provided. But it was really for her that she had to move.
Okay, thank you. Any questions here? Is the amount of time that you've been in Canada a criteria for a decision regarding social assistance?
So when it comes to the impact of immigration status, the answer would be maybe. So if they're saying that you're a visitor and you've only been in Canada for 2 weeks and you haven't established yourself here, yeah, you're probably going to be found to be a visitor in the plain language meaning. In terms of just in general, the answer is no. You have to be a resident of Ontario, though. So if you're in and out, then they could say, well, you're not actually living in Ontario, but that's a separate discussion to immigration status. Okay, and I have another question, Martine, just to clarify, if people have made a refugee claim but are waiting for their hearing, they are eligible, even if there isn't a decision yet. If you can just repeat about claimants, please.
Yeah, so if a person has made a claim in Canada and they are waiting, they would still be considered a refugee claimant, and refugee claimants are eligible for social assistance.
Great. Let's see if we have any other. Workers or visitors who are married to a Canadian spousal application are encouraged. to apply for social assistance. We are going to talk about sponsorship in the second half. There's a question, what about a minister's permit? And maybe if you can elaborate what you were saying, Martine, that it's no longer called that, but if you can explain, please.
So it was previously called a minister's permit, and now it's called a temporary resident permit. I don't remember if I did mention some examples, but we've seen people who've received temporary resident permits for example, a victim of human trafficking. So someone who came to Canada and maybe were in a situation where they were being exploited by an employer, for example. In some cases, they may receive a TRP, so a temporary resident permit, and that gives them a temporary status. So they're not a visitor, but based on their status, because they're not visitors, they don't have a removal order that's enforceable. Usually they are eligible for social assistance as well. And I think it's something that we did mention earlier. And I don't know, was there another question about?
Similar, it's kind of, you said somebody who's been trafficked, but also they're saying, can a person with a TRP apply for social assistance in the situation of domestic violence?
Yes. So, and there are also TRPs. For now, there is a special TRP for people who have been in situations of domestic violence. So, yes, if someone does apply and they do get a TRP in that context, they would also be eligible for social assistance.
And then somebody else is asking, is that the same as a temporary resident? If you could just make that distinction again between TRP, please.
Yes, so there's temporary resident status, which is kind of like the umbrella term, which will include visitors, foreign workers, students. So all of these, so students, workers, visitors are all considered temporary residents. TRP holders are also considered temporary residents. And then earlier I had also mentioned a temporary resident visa, which is a document that's found in a passport. So that's not a status per se, it's just it's like something that it's like a way of essentially getting to Canada. So really the difference between the two is in terms, the temporary resident status is really the umbrella term, which encompasses all of those categories. And in most cases, they are eligible for social assistance.
Thanks, Martine. Okay, I have time for one more. Just clarification, if a refugee claimant gets a negative decision in their hearing, does that affect the social assistance they're receiving? And then I think we will move on to part two, but there'll be time for questions again at the end. Thanks.
Yeah, that's a good question. And I know that that comes up often when there is a refusal, and clients can also be very worried and think that their assistance will be cut off if they get a negative decision. But like we mentioned earlier, if a person does make a claim, if they are denied, if they intend on appealing that decision, then during that time, they would still be considered a refugee claimant, so they would be eligible. But if the person who's denied has exhausted all of their appeals, then at that point, we look at the question of whether or not they have a removal order and whether or not that removal order is enforceable. So that would really lead to that question. And then depending on whether it's enforceable, or if, for example, if they applied for maybe an H&C application, then they may still be eligible, for example. So it really depends on the facts.
Okay, thanks so much. We will move along now to kind of part two, and there's time for questions again at the end.
Okay, so now we're going to talk about how social assistance can affect immigration applications. So in some immigration applications to Canada, one of the factors that IRCC will look at is whether someone is able to support themselves financially. And in those types of applications, whether a person receives social assistance can have an effect, but in most applications, receiving social assistance is not affected. So we're going to talk about sponsorships, which is one of the types of immigration applications where we do see that there can be a potential impact on the sponsor. So that's the person who's here in Canada who wants to bring a family member or sponsor a family member to Canada. So the receiving social assistance could potentially have an impact on a sponsor, or it can also potentially have an impact on the applicant, so the person who's being sponsored. So it's just really important to know that that there are some applications that can be affected if someone is receiving Ontario Works. And just wanted to mention that different rules do apply for people who are receiving ODSP, so Ontario Disability Support Program benefits. And then also, I just wanted to mention, because we did talk a lot about refugee claimants, that a refugee claimant, for example, who receives social assistance, that doesn't have an effect on their refugee claim, and it doesn't also, it won't affect their application for permanent residence if they are successful. So we're going to talk more about sponsorships at the next slide. Okay, so what is a family sponsorship? A family sponsorship is basically IRCC allows Canadian citizens and permanent residents of Canada to be able to sponsor their family members and to join them here in Canada. So usually the typical sponsorships is usually for a spouse, a common law partner, children, and other relatives. If you have temporary resident status, so that means if you're a visitor, foreign worker, a student, a TRP holder, you cannot sponsor anyone. If you don't have regularized status, you also cannot sponsor someone. And essentially, really, you just have to be Canadian or permanent residents. If it's not one of those, then you can't sponsor. As I mentioned before as well, there is an impact of receiving social assistance unless it's for a reason just for disability. And if, for example, you are making an application to IRCC for a sponsorship and you are receiving social assistance, so the sponsor is receiving social assistance and IRCC finds out, that can also put the sponsorship application at risk. So when someone is sponsoring a family member, they'll have to fill out lots of immigration forms. And in one of these specific immigration forms, they do ask questions related to social assistance. So it's important to note that if you have to be honest when you're making these applications, and it's important to get some legal advice if you are receiving social assistance, because it could have an impact. And if you don't tell immigration that you are receiving social assistance while applying to sponsor, for example, a family member, that can have potential legal consequences on the application. Okay. So if, for example, you know, I want to sponsor my child, and I'm, for whatever reason, maybe I've lost my job, I'm not able to work right now, and I really want to be reunited with my child, and I really need to file an application. Or maybe my child's in a situation where, you know, a very precarious situation, and I'd like them to come and join me to Canada. In those cases, you know, you are receiving social assistance, which means that I wouldn't be eligible to sponsor my child. But there can be reasons maybe why I can't get off that social assistance. And in those cases, you know, we usually advise to get legal advice to see if the sponsor may still be in a position to file an application to be reunited with a family member, even though they are receiving social assistance, because there may be some compelling reasons to do so. And usually that would involve making a request for humanitarian and compassionate grounds and explaining why you're receiving social assistance. You know, if you have a plan to become self-sufficient financially, you would explain that. And then you just ask for IRCC to use their discretion to allow you to still sponsor that family member. So it is possible to do these types of applications in the context of a sponsorship application. However, it is discretionary because once again, you're asking for IRCC to make an exception to the rule that if you want to sponsor a family member, you need to show that you're going to be able to provide for that person without having to rely on social assistance and without the family member also having to rely on social assistance. So these requests can be made in certain circumstances. It really depends, and it's best to just seek legal advice if that's the case. And this slide is just to explain that in some cases, we have often clients who receive the Canada Child Benefit every month, which is a benefit that's through the federal government. And just to mention that this is not considered, the Canada Child Benefit is not considered social assistance for purposes of immigration law. So if someone receives CCB for their children, they don't have to worry about whether or not it will have an impact on a sponsorship application. So we just wanted to mention that. And also while we're discussing this particular benefit, I did want to mention that there is a campaign going on right now to open up benefits to all children. Some of you may know that the Canada Child Benefit is only limited to, not available to everyone. There are some exceptions, and there is a campaign currently towards the federal government to allow benefits to be open to all children in Canada, regardless of their parents' immigration status. And there is a petition that is going around. So people are obviously more than welcome to sign that petition if they would like. And we did provide a link to that at the end of the presentation, and people can have a look at that after.
So we have another scenario for all of you. So this one's a shorter one. Mohammed is a permanent resident and he receives Ontario Disability Support Program benefits because he can't work as a result of a workplace injury. He has chronic back pain and suffers from depression. So I'll ask you to put in the chat, can Mohammed sponsor his spouse while he receives ODSP? We have a lot of yeses coming in furiously, Martine.
Yes, we do. Well, I'd say that you are all right if we move on to the next slide. So can Mohammed receive, so yes, Mohammed receives social assistance because he has a disability. So Mohammed can apply to sponsor his spouse. And he can apply to sponsor his spouse because he's not receiving Ontario Works, he's receiving ODSP, and it is because of a disability. And the immigration rules allow you to sponsor if you receive social assistance because of a disability. However, if once your family joins you in Canada, they should not be included in your benefit unit, because then that would mean that your family member is also receiving social assistance. And in the context of a sponsorship, when you're promising that you will support someone when you file a sponsorship application, you just have to ensure that the person you're sponsoring does not have to apply for social assistance. So that's really the difference. So if you're receiving Ontario Works, then the general rule is you cannot apply to sponsor someone. But if you are receiving ODSP benefits because of a disability, then yes, you can apply to sponsor.
This is kind of a relevant time to jump in with a question. If a person's on ODSP and they're sponsoring their spouse, can they have a co-sponsor, or do they need a co-sponsor?
Yeah, that's a good question. So if a person is on ODSP and they want to sponsor their spouse, so generally, if you're sponsoring a spouse, then the sponsor would be the partner. basically. And if you're on ODSP, then you don't need a cosigner. You just have to show, and this is where, you know, it's still advisable to get some legal advice, because the person that that's the applicant, so the person that will be joining you in Canada cannot receive social assistance. So you'd have to show how is that person going to support themselves without having to rely on social assistance. So usually we would advise to get advice, but it isn't necessary to have a co-sponsor in those circumstances.
Thank you.
So in terms of the responsibilities of a sponsor, so if you are sponsoring a family member, you have to sign a document that's called a financial undertaking. And what that means is that you're promising to provide financial support for a certain period of time. And the person who sponsors a family member under the sponsorship program signs the agreement, and the applicant as well. So the family member signs that agreement as well. And basically it says that you're going to provide that support for a certain amount of time. And I think on the next slide, or maybe further down, we will kind of list the different lengths for those agreements, which are called undertakings. And while we're on the topic of the responsibilities of the sponsor, we did include an excerpt from one of the immigration forms for sponsorship applications. And this excerpt is found in the application to sponsor immigration form, which essentially says that when a sponsor files an application to sponsor a family member, so first of all, they sign the undertaking, and you'll find that here. And then basically what I've highlighted is, one of the sections I've highlighted is, it says in the undertaking that I promise that the sponsored person and his or her family members, if you're sponsoring more than one person, will not need to apply for social assistance. So it's clearly written in the immigration forms what the undertaking is. So it's really important if you're going to sponsor someone to carefully read that, because all of the details related to your promise and the impacts of social assistance are all included in that immigration form. And what we also find in the undertaking is the length of time that you will be responsible financially for the person that you're sponsoring. And it really depends on who you're sponsoring. So we've included some examples here. You'll even see, for example, if you're sponsoring a parent or grandparent right now, it's a 20-year promise to provide financial support. So that means that for 20 years, your parent or grandparent shouldn't be relying on any form of social assistance. So really that length of time depends on who you're sponsoring.
So we have a third scenario to put to you all, and hopefully you can answer this one in the chat as well. So we have Mario has applied to sponsor a spouse, Raul, who lives with him in Canada without status. Mario receives ODSP and has included Raul on his ODSP benefits as a spouse, but Raul does not have a disability himself. Will this affect Mario's application to sponsor Raul to become a permanent resident? You have a couple yeses. Anyone else? Less enthusiastic unanimity, Martine.
So yes, so Raul is receiving social assistance through Mario's ODSP, but Raul doesn't have a disability. So Raul and Mario, what they can do is they can write to ODSP and they can ask Raul to be removed from the ODSP unit. And then they can share this fact with IRCC before a decision is made on the PR application sponsorship. So because other than that, Raul's application for permanent residence will be refused if he does not stop the spousal ODSC benefits that he receives. So what happens if the sponsored person receives social assistance? So if a sponsored person receives social assistance during that undertaken period, so it could be, for example, if it's a spouse during those 3 years from the moment that they become a permanent resident, then the sponsor may be found to be in sponsorship default. And then, so if during, for example, if we take the example of a spouse, there's a 3-year promise to provide financial support. If for any reason the spouse receives social assistance, then the sponsor will have to repay the government the amount of social assistance that their spouse received. And just maybe to mention, how would the government even find out that the sponsored person has applied for social assistance? So what some people don't know is that sometimes the Ministry of Community and Social Services, so that's the ministry that overlooks the Ontario Works program, sometimes they can either the spouse, for example, might file an application, and then the ministry, so Ontario Works, will then contact the sponsor and ask them, like, why aren't they supporting the person that they've sponsored? So that could be one way for government to find out. And sometimes, you know, the government may not find out, but they could find out later on, and then at that point you would have to repay the social assistance. So those are just things to keep in mind. And again, I've included, highlighted a few portions of the undertaking from the immigration forms that do talk about the seriousness of the promise to provide social assistance. Some of the parts that I've highlighted are, and I'll read them out to you because it is a bit small. So I understand that the undertaking remains in effect no matter what may change in my life. So for example, even if you get divorced with the person that you're sponsoring, or if you change jobs, if you become unemployed, or if you decide, you know, I'm sponsoring this person, but I decided I'm going to go back to school, you're still going to be responsible to the sponsored person that you are sponsoring. And if you breach any of your sponsorship obligations, you will be in default. The undertaking will also states that you understand that all social assistance that has been paid to the sponsored person becomes a debt to the government. And then the government and the province may choose not to take enforcement action to recover the money, but that really depends. And an important thing also to know is that even if, for example, you've accumulated a debt because you know the person that you've sponsored has received social assistance, even though you may be in a situation where you can't reimburse or pay back that debt, the debt is never canceled. It still remains. It's just going to be, it's up to the government to decide whether or not they will actually try to recover that money. So really the point why we've included this, the excerpt of the undertaking, is just to show like the serious language when it comes to sponsorships, and that it is an important thing, factor to consider before sponsoring someone. Because oftentimes people don't realize, they just think they're going to be reunited with their family, but they don't realize that it is an agreement. It's almost like a contract that you have between yourself, the person you're sponsoring, and even the Canadian government.
Before we move on, can I just ask two little questions that are kind of coming up at a relevant time? What if one of the circumstances is that what changes in the sponsor's life is that they develop a disability? It's question one. And then what if, say, sponsored parents, for example, should apply for subsidized housing during the period of the undertaking? If you could please answer those.
Okay, so for the question about the disability, so if there is a debt and there's a disability, in that case, as I mentioned in the undertaking, it does say that the government may choose not to take enforcement action. However, it still remains a debt. So it really is just a question of whether or not the government will take action. And usually we would just suggest getting legal advice to see how you can explain the situation so that you're not having to reimburse a large amount of money. And then the second question was about subsidized housing. So just quickly, immigration law does have a definition of social assistance, and shelter is included in that definition. However, recently I did find that on the immigration website, they do briefly explain what they just determined to be social assistance. And to my surprise, subsidized housing is not, they don't consider subsidized housing to be a form of social assistance, which we've always advised our clients that it could be seen as social assistance, but it appears that according to IRCC, it is not a form of social assistance for the purposes of sponsorship applications and being found in default of undertaking.
So we have our last scenario. It's a two-parter. So Selena and Isaac. So Selena sponsored Isaac, who became a permanent resident in 2019. After coming to Canada, he became aggressive and would often yell at Selena. Selena didn't feel safe, and her friends offered to help her leave him. The first question for everyone is, and I'm seeing answers in the chat already, does Selena have to continue to live with her husband? Do you agree with them, Martine?
I agree. So no, and IRCC also agrees. No, Selena does not have to remain in her relationship with her husband. So IRCC acknowledges that these situations can come up, and they don't expect people to remain in abusive relationships. And Isaac has no obligation to remain in a relationship with Selena either, and he will not lose his status if they split up. So that's great. I think most people got that. Just another question. So if after they split up, Isaac applies for social assistance tomorrow, for example, will Selena be in default of her undertaking? So I see some yeses. So yes, I'd say most of you are right. Selena
Somebody asked, somebody
Oh,
asked
no.
if you can cancel the sponsorship just while you're answering.
So the answer is no, and then you'll find even in the undertaking, so in the excerpts that we've provided, and you'll get the slides after the presentation. In the undertaking, it is clearly written that the debt cannot be canceled. So in the case of Selena, she will likely be found in default. So although, yes, she can certainly leave the relationship, there's no requirement that she stays with Isaac. She will still be found in default, unfortunately, because the government doesn't want people in Selena's situation to feel trapped or in danger. They may still agree to defer the payment of the debt. Or they may accept like a minimum monthly payment or work out like a payment plan. So they can lower the amount. They can maybe like stretch it over time, but they will never forgive the debt, unfortunately. So yeah, best to get legal advice in those situations.
Okay, and related, we're also getting a question, if Isaac becomes violent, can Selena apply for him to be removed from Canada?
It's a good question. So once Isaac has become a permanent resident of Canada, there isn't anything that Selena can do in terms of his immigration status. So Isaac cannot lose his immigration status because he's being violent. However, as we mentioned earlier, permanent resident status isn't necessarily permanent. And if for any reason Isaac was in a situation where, there were charges that were made against him and he was found in a situation where there may be some type of criminal inadmissibility, then, that could lead to some consequences for his status. But there isn't anything that Selena can do in terms of the fact that there's been violence in the relationship or a breakdown in the relationship.
Right, she can call the police, but she can't call immigration.
Exactly.
Thank you. Okay.
So as community workers, what can you do to help your clients? So we've listed a few things here. Obviously, you can help your clients try to understand the difference between receiving Ontario Disability Support Program benefits and Ontario Works for some immigration applications. And then when in doubt, just refer your clients to their local legal clinics. And then we can just assess and give them advice. Sometimes we can even represent them in certain circumstances. And I know often clinics are also very open to chatting with community workers if they have some questions or they want to have a better understanding of the law and how it affects their clients. So just reach out to your local clinics, and there are lots of resources as well that are available. And we've provided those at the end of the presentation.
Great, amazing staying on time. There's some questions that are further back in all the answers. Okay, if the sponsor has divorced with the sponsored wife, not because of violence, can the sponsored wife apply for social assistance?
So for this scenario, just a reminder that if you're sponsoring a spouse, it's a 3 years undertaking. So if within that 3 years, there is a divorce, the undertaking remains in effect. So whether or not you're divorced, as we saw earlier, it doesn't change the length of the undertaking. And if the sponsored spouse applies, what may happen, as we mentioned, Ontario Works may contact the sponsor to ask them why they aren't sponsoring their spouse. So even if you are divorced as a sponsor, you're still responsible for your spouse, even though you're divorced. And if that spouse does end up getting social assistance, then you're going to have a debt, unfortunately, that you may have to repay.
And I'll just jump in from the social assistance perspective. Sometimes that sponsored person comes to us to say, oh, well, Ontario Works said that I'm under a sponsorship, so my ex-spouse needs to pay. And while that's true as a first step, if the person who is supposed to pay is not paying, we can get social assistance to give that person benefits. So it does become a debt to the ex-spouse, but that doesn't mean that they're not entitled to benefits. It just means that the ex-spouse has to repay it.
Okay. Thanks. That it's more a contract than it is a marital status thing. And the contract is 3 years. Okay. Somebody had a client that was on ODSP and they got an invitation to sponsor their grandparent, but they needed a co-signer. And on the website, it said only a spouse or common law partner can co-sign, but this person doesn't have a spouse or common law partner. Is there a solution for them?
So in a case like this, I would usually suggest contacting a local legal clinic for advice, because it really is more fact specific. It is a good question though. But it is difficult to answer because it can depend on the circumstances. So usually we would just suggest in those cases to get legal advice, just to get some advice that's more tailored to the person's situation.
Excellent. Another plug for your local legal clinic that understands these issues. Okay, if a sponsor loses their job and finishes their EI entitlement, would OW be an option for them?
So it would be this, in this case, the sponsor is receiving social assistance. That's interesting. It's not something that I see very often, but not sure. I don't know, Gillian, if you've seen a situation like that in the context of social assistance, but if the person if the sponsor is receiving social assistance I think the issue again comes down to the person that you're sponsoring. There's going to be an issue with the whole benefit unit and whatnot, but I'm actually not sure for this question. I don't know, Kristin, do you know? I've never seen that situation.
I think the
Yes.
mantra to go get legal advice would be
Yeah.
important, and also that to watch the benefit unit. The only thing that occurs to me is that if it were just related to the sponsor, maybe, but if you started to have the sponsored person because of that undertaking and contract, but regardless, I'm reluctant to say anything definitive.
Yeah, exactly.
Also, so that would be a situation to go to your clinic.
Yeah, I think it also depends what point in the process you're at. So if you're trying to sponsor someone and you're applying, that's going to be a problem. But if the person is already here and you've sponsored them, then if you receive
Yes,
social
you can
assistance,
apply.
it's a benefit unit issue, right? It's like who
Mhm.
is in the benefit unit. Technically speaking, the family should be in the benefit unit. Oftentimes you can negotiate something. But sometimes people will say, well, I want to receive the money and I know it's going to be a debt, but like, what am I going to do to pay my rent? So I need to receive the money now. And I know I'm
Yeah.
going to owe the rest of it back later.
You
And
know,
I'll
do
deal
you
with
want
it
to
later.
say-
Yeah. And one thing I just wanted to mention, just like Gillian said, it really does depend whether or not you filed an application. So, or whether or not the person's already here. If you've filed an application to sponsor a family member, but that family member hasn't arrived in Canada yet, they haven't become a permanent resident yet. What IRCC says in the law is that from the moment that you submit your application up until the time the person arrives, you have to be eligible to sponsor that person, which means when you're filling out your application to sponsor, they do ask the question if you are receiving social assistance as a sponsor, because if you are, then you're not eligible to sponsor. But if, for example, you file an application and you're working when you file your application, and then 6 months down the line you lose your job and you have to apply for social assistance, then at that point you no longer meet the criteria to sponsor your family member, and you would have an obligation to notify IRCC of this fact, because that can have an impact on your application. So it would be important in that circumstance for a sponsor to get legal advice as well.
Great, thank you. I'm going to see if there are more questions. And just while we're doing that, there are links here included in the slides to legal information and places to go for help, campaigns and organizations. Somebody was asking about, how can we move to get social assistance rates higher? And there are people working on these issues here, including the Basic Income Project. We have the photo credits from the first thing. And I think we have time for another. What are some of the free legal aid clinics in Ontario as people on ODSP can't afford to pay? So there is, if you go to this link right here, this has a link to the community legal clinics. It's a hyperlink, and you go there, then you put in your local postal code, and it will let you know of the community legal clinic in your geographic region. And we also have what's called specialty legal clinics that do advocacy on community-based issues, legal issues as well. Any other, I think we are so well timed. I have to absolutely hand it to Martine and Gillian for being excellent presenters and on time. Okay, here we have how many months should pass after being off OW before being able to apply for sponsorship? Actually, that's a question that was repeated, so that's a good time. How clear of social assistance do you have to be to apply to be a sponsor?
How many months should pass after being off before applying to I mean, there isn't like a specific set amount of time. One thing that we do advise our clients usually is if they were in receipt of social assistance and they'd like to sponsor, that they should follow up with their local office, Ontario Works office, just to make sure that they've actually closed their file. Because of the fact that IRCC and the Ministry of Community and Social Services do have an agreement to share information. If that person files an application, but they're not receiving social assistance, and then IRCC checks with OW, it may come up that they have a file that's still open, even though they're not receiving social assistance. So we always advise to make sure that the file has actually been closed. And I have seen some clients who were able to get a letter from Ontario Works confirming that their file has been closed. And then it's really just a matter of being able to show IRCC that you have the means to support the person that you want to sponsor.
Excellent answer. I think that brings us to the end of our time, and thank you both, Martine and Gillian, and audience, for your excellent questions and good answers in the chat with the scenarios. So these will be posted, the slides, and so thanks very much, everybody.
Everyone.
Thank you. Thanks, Kristin and Gillian. Bye.
Bye-bye. I stopped sharing. People were asking where exactly the slides will be posted, but I'm sure that information is available on the OCASI website. I also realized we'll add the links to the ADR and TSR list next time. Okay. Why don't we
Okay, so I'm
go?
going to end the meeting now, and then we should be good to go.
Okay,
Thanks.
thanks so much.
Thank
Bye.
you.
I don't know how the French worked, but we didn't get any questions in French, at least not for